Parole evidence, Section 10. Evidence is evidence of written agreements when the terms of an agreement have been all the terms agreed upon, and there can be, as between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreements. However, a party may present evidence to modify, explain, or add terms of written agreement if there she in issue in a verified pleading. Intrinsic ambiguity, mistakes, or imperfection in the written agreements. B. The failure of the written agreement to express the true intent and agreement of the parties thereto, the validity of the warrant agreement, or the existence of other terms agreed to the parties or their successors. In interest after execution, the written agreement, the terms agreement includes wills. Section 11. Interpretation of a written according to its legal meaning. The language of writing is to be interpreted according to the legal meaning to bears the place or execution unless the parties intended otherwise. Section 12. Instrument construed so as to give effect all provisions. In construction of all instrument where the several provisions or particular such construction is, if possible, to be adopted and will be give effect to all. Section 13. Interpretation according to the intention, general and particular provision in the construction of an instrument. The intention of the parties is to pursue, and when a general and particular provision are inconsistent, the latter paramount, the former, so their particular intent will control a general one that inconsistent with it. Section 14. Interpretation according to circumstances for the proper construction of an instrument, that circumstances under which is made, including the situation of the subject thereof, and it is the parties to it, may be shown so that the judge may be placed in the position of those whose language he or she is to interpret. Section 15. Peculiar signification of terms. The terms of a writing are pursued to have used their primary general acceptations, but evidence is admissible to show that they have a local, technical, or otherwise peculiar significance and were used as understand in particular instance, which case agreement must be construed accordingly. Section 16. Written words controlled printed. When an instrument consists partly of written words and a partly of a printed form, and two are inconsistent, the former controls the latter. Section 17. Experts and interpreters to be used, explaining certain writing when the character in the which an instrument is written are difficult to decipher or the language is not understood by the court. The evidence of a person skilled deciphering the characters or who understand the language is admissible to declare the characters of the meaning of the language. Section 18. Of two construction which preferred with terms agreed have been intended to different sense by different parties to it, that the sense of the prevail against either party in which she is opposed to the other understood it when in the different construction of provisions are otherwise equally proper. Section 19. Construction in a favor of a neutral right. When an instrument is equally susceptible of two interpretation, one favor natural right, the other against it, the former is to be adopted. Section 20. Interpretation according to the usage. An instrument may be construed according to the usage and the other determine that its true character. Testimonial evidence. Section 21. Witnesses, their qualification are person who can perceive, and perceiving can be known. Their perception to others may be witness, religious or political belief, interest, or outcome on the conviction of the crime unless otherwise provided by the law shall not be a ground for disqualification. Section 22. Testimony confined the personal knowledge, and witness can testify only those facts which he or she of his personal knowledge that is which are derived from his or her perception. Section 23. Disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against against the other without the consent affected spouse, except in civil cases by one against the other, or the criminal case where crime committed by one against other or the latter direct descendant or ascendants. Section 24. Disqualification by reason of privileged communication. The following persons cannot testify as matters learned in confidence in the following cases. The husband and the wife during or after marriage cannot be examined without the consent of the other, as the communication received confidence by one from the other during marriage, except civil case by one against the other. A person licensed to practice medicine engage the diagnosis of a treatment of mental emotional condition by a person licensed by a psychologist by the government, while similarly engage a semester priest or a person reasonably believed be so cannot without the consent of the affected person can be examined to any communication or confession made to or any evidence given by him or her in his or her professional character in course discipline enjoined by the church to which minister priest belongs. Testimonial privilege, section 25. Parental and filial privilege. No person shall be compelled to testify against his or her parents, other direct ascendants, children, or other direct descendants, except such a testimony is indispensable in a crime that a person or one parent consists to another. Section 26. Privilege relating to trade secrets. A person cannot compel to testify about any trade secret unless the non-disclosure will conceal fraud or otherwise work injustice. Admission and confession. 27. Admission of party. The act of declaration, omission of party as to relevant fact may be given evidence against him or her. Section 28. Offer of a compromise or not admissible in civil case or after the compromise is not admission of any liability is not admissible evidence against the offender. Neither is the evidence conduct nor statement made is compromise negotiation admissible except evidence otherwise discovered another purpose such as proving bias or prejudice of a witness, negativing a content of undue delay, or providing an effort obstruct of a criminal investigation. In a criminal case, except those involving quasi-offenses, criminal negligence, or other allowed by law to be compromised, an offer to compromise by the accused may be received in evidence as implied admission to guilt. Plea of a guilty letter withdrawn, and an acceptable offer plea of guilty to a lesser offense is not admissible in the evidence against the accused who made the plea of offer, neither any statement made in which does not result in any plea or guilt or which result to the plea latter withdrawn admissible, and expenses occasioned by the injury is not admissible in the evidence proof or civil criminal liability for the injury. Section 29. Admission by third party. The rights of a party cannot prejudiced by an act, declaration, omission of another except hereinafter provided. Section 30. Admission by a co-partner or agent. The act of declaration of a partner agent is authorized by the party to make a statement concerning the subject or within the scope of his or her authority, and during the existence of a partnership or agency may be given any evidence such party after the partnership of agency is shown by the evidence or the act of declaration of the joint owner, joint debtor, or other jointly interested with the party. 31. Admission by conspirator. The act of declaration by conspirator is a furtherance of the conspiracy and during existence may be given evidence against the conspirator after the conspiracy shown evidence by then such act of declaration. 32. Admission of brevis. Where are derives title of the property from another, the latter's act, declaration or omission in relation to the property or evidence against the former if done while the latter was holding the title. Section 33. Admission by silence. An act of declaration made by presence and within hearing of observation of a party who does not or say nothing when the declaration is such a naturally to call actions to comment if true when proper and possible for him to go to do so may be given evidence against him or her. Section 34. Confession. The declaration of an accused acknowledging his or her guilt to be offense charged or offense necessarily include therein may be given evidence against him or her. Provisions conduct as evidence. Section 35. Similar acts as evidence. Evidence one did or did not do certain thing that one time is not admissible to prove that she or he did not do the same similar thing to the another time, but it may be received to prove a specific intent to act, to knowledge, identity, plan, system, scheme, habit, custom, or usage, and the like. Section 36. Unaccepted offer. An offer is in writing pay particular sum of money or to deliver written instrument or specific personal property is if rejected without the valid cause or equivalent to the actual production and tender of the money, instrument, or property.